This hearing is in the matter of case number CFI 096-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing from the UK. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by DLA Piper Middle East, LLP. Lead counsel is Mr. Andrew Mackenzie. The defendant is represented by Al-Dhahri International Advocates and Legal Consultants. Lead counsel is Mr. Sean D. Yates. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed, thank you.
It is from the claimant side, thank you.
Yes, and from the defendant side.
Thank you all.
Yes, Mr. Mackenzie, it's your application.
Thank you, Your Honour. Can I please confirm, because we've been trying to reach the court since this morning, that you have in front of you the two additional authorities that were submitted this morning to the court. The first is Industrial Group Limited, and the second is Gustav Novian v. Freeman.
Well, I've got the email with the attachments, but I haven't opened up the link as yet.
No, not at all. And I appreciate and apologies for the late submission. The first is obviously a well-known DIC court judgment, so I'm sure your Honour will be familiar with it. The second was actually an authority that we noticed had been referenced frequently in the dicey extracts that the defendant submitted, and we thought it would be useful for it to also be included in the bundle, given its frequency. But I'll come on to its relevance in a bit. I'll assume, obviously, Your Honour has read both parties' skeletons. What I propose, given the detail of our skeleton, is I don't want to go through them, through the skeleton page by page, but I just wanted to pick up on a few key points, but also address some issues that were obviously raised, in some cases for the first time, by the defendants in their skeleton argument, if that would be of assistance to Your Honour.
Well, there are, I think, only 2 or 3 points that matter here, aren't there? One is the Riyadh Convention, one is the question of what's final and conclusive, and one is the question of the effect of bankruptcy in Kuwait. So yes, those are the matters upon which you need to focus.
Yes, entirely, and that is in effect my opening summary of the 3 issues. So that was being really helpful. Thank you. I think what I would like to do is address, because we're here to discuss the issue of an amendment to the claim and not the substance of the claim itself, beyond the real prospect of success point. I'd like to start dealing with the issue of the test for amendment and just go quickly through that.
I don't think I need you to address me on this in any great detail. You can tell me in one sentence what you say it is, and if there's any dispute about it, we'll hear further argument.
No, understood, Your Honour. That's very helpful. I mean, the full test from the claimant's perspective is set out in section D on page 6 of our skeleton, so I won't go into detail on that. But in essence, the test is well captured in the Oman Insurance v Global Med Gulf case, and Your Honour will be very familiar with that. So I won't go through the issues there. The only thing we wanted to highlight in the context of the real prospect of success, obviously from our perspective, the defendants have conflated the issue of recognition and enforcement, and they do this throughout their submissions. Their submissions have also narrowed considerably from the submissions they were making earlier in the year to what their skeleton ultimately focuses in on. And in terms of the 2 main points that the defendants make, it's the Riyadh Convention, as Your Honour has raised, and the applicability of English law. Neither, we say, is relevant to this particular issue, but I'll address the Riyadh Convention next. But in terms of the concept of the real prospects of success, obviously, I just want to be very clear, and I'm sure it is clear to Your Honour, but clearly not to the defendant. The real prospect of success for us is recognition of the judgment. It is not enforcement of the judgment. It is pure recognition of the judgment. That is what we would advocate is the test for whether there is a real prospect of success in relation to our amendment in order for it to go forward to succeed. We'd obviously maintain that there is a real prospect of success because the test under the DIC law is very clear in Article 24 with why foreign judgments or how foreign judgments should be enforced, and indeed the case authority on these points are also really quite clear. So that shifts us neatly onto the position of, and again, I won't bother Your Honour with the tests laid out in Oman in detail, but we did want to pick up one point because we suspect the defendant will want to labour this point quite considerably, which is the issue of prejudice. From our perspective, the defendant hasn't been in any way prejudiced as a result of these proceedings. In fact, the contrary is the case, and any prejudice created in these proceedings have been created by the defendant's actions, first and foremost in not engaging with the proceedings until the 11th hour. And Your Honour will recall the last time we discussed and met at a hearing, it was to essentially vacate that hearing as a result of an email received the night before from the defendants, which is the first time they engaged in the proceedings. But we know for a fact that they had copies of these proceedings at latest in February, and that hearing was in May. And there's no justifiable cause, and nor indeed did the defendants present one, to justify that late engagement. But we then very practically and in line with the overriding objectives sought to agree a way forward with the defendants, including, despite the fact that they had served an acknowledgement out of time, we agreed to waive our objection to that and propose an amendment in light of the evidence they presented us. They, of course, proposed this amendment, and now we find ourselves dealing with an issue which, from our perspective, is very straightforward. So if there is any debate as to whether there's an issue of prejudice or as that relates to costs, which I know we're not here to discuss today, our position is very clear that we've proceeded in line with the rules and the orders laid down by Your Honour. The defendants have not, and have prejudiced themselves because they've refused to proceed on a common sense basis and in line with the overriding objective. So that brings us neatly to the test for recognition. And obviously the defendants are arguing that the Riyadh Convention, and as I said, there's only two arguments in their skeleton that they've advanced now. One is that the Riyadh Convention applies, which I'll address shortly. And the other is that even if the Riyadh Convention did not apply, English law would apply in this instance. We say the second point is a non-starter for 10, and it's very easily addressed and dealt with. So that will be a very short part of my submission. But turning to the Riyadh Convention issue with respect to whether or not it applies. In summary, our position is that the Riyadh Convention does not automatically apply in the DIFC, and the Lahela case dealt with that very clearly. The defendant's position is that that case only addressed issues of service, and everything else was with respect to these issues of recognition and enforcement are separate and distinct from the reasoning in that case. The claimant takes issue with that because fundamentally the reasoning in that case is actually very illuminating, and it does address, as per our skeleton, what the Court of Appeal's viewpoint was with the effect of the Riyadh Convention, and that it was not just talking about it with respect to service, but it was talking about it with respect to the round. But what I wanted to do was just draw your Honour's attention to the specific wording of the Riyadh Convention. And it's Article 30. Which I believe is set out on page 942 of the bundle. Does Your Honour have that up in front of him?
Yes.
So Article 30 is one of the primary bases the defendant uses to rely on the refusal to recognise judgments. And it says that the recognition of judgment shall be refused in the following cases. And the last one is if the dispute is also the subject of a case being heard by the courts of the requested party, and the action that has been brought before the courts of the requested party on a date preceding the presentation of the dispute to the court of the requesting party. But interestingly enough, there's additional wording below that, which says the judicial body examining the request for recognition, in this position the DIFC courts, in accordance with the text of this article, may observe the rule of law in its own country. So far from the defendant's position that that provision is mandatory and you are bound to adhere to it as a matter of law, the article itself actually states that you have the discretion to apply DIFC law or the DIFC law approach with respect to that. And that's actually clearly set out in the case previously mentioned that states that the Riyadh Convention is not automatically or does not automatically form part of DIFC law. The other aspect that I wanted to draw your Honour's attention to is within the reasoning of the Lahela case, you also have reference to the fact that when it comes to matters of procedure, essentially the DIFC court can and will rule applying its own law in this instance. And of course, we would argue that the DIFC law in this position under Article 24 is abundantly clear with respect to that. The reference I want to make to Your Honour, and again, I'm sure you're familiar with the case in question, but it's paragraph 106 of that case, which is at page or tab F5, page 721.
Yeah.
That paragraph essentially says the submissions of the parties on this issue proceed on the assumption that the decision of this court in IGPL against Standard Chartered Bank to the effect that UE Civil Procedure Code is a federal and civil commercial law, which does not therefore apply in the DIFC, is correct. It follows that if and to the extent that either the convention generally or Article 6 of the convention is properly characterized as a law relating to civil procedure, it also excluded from operation within the DIFC. So the Court of Appeal has made stated that any procedural matters for which the recognition of a foreign judgment would fall into, if the article in the convention relates to that, then fundamentally that still does not automatically incorporate that into DIFC law, and DIFC law itself would take precedent. So that case, coupled with the wording of Article 30, from our perspective, at a very high level, obviously we've detailed this more substantively in our submissions, draws the clear conclusion that the Riyadh Convention cannot apply and does not apply in this instance.
Well, what do you say about Article 24.2 of the Court's law?
So if we turn to Article 24.2, it's on page 843 and 845. Article 2 says where the UE courts has entered into an applicable treaty for the mutual enforcement of judgments, orders, or awards, the court's persons should comply the terms of the treaty. We would argue that that is purely in relation to enforcement, not recognition. As I said, we are not seeking to enforce the judgment. We are just simply seeking to recognize it. And that's the basis of our claim. That's always been the basis of our claim in this context.
Well, I didn't understand that. Is the Riyadh Convention a treaty for the mutual enforcement of judgments, first of all?
The purpose of the treaty is covering a number of different things.
Yeah,
it does cover both.
Yeah,
it does cover recognition and enforcement in the context of civil and commercial matters.
So where you've got a treaty that is for the mutual enforcement of judgments, as a matter of DIFC law, the court has to comply with the terms of the treaty. And the terms of the treaty include Article 30E. And so I have to apply Article 30E unless you can persuade me that the final sentence means that I don't have to.
Yes, essentially. So our position would be that it is the wording of Article 24.2 specifically mentions mutual enforcement of judgments, not recognition, and therefore the aspects of the treaty. Sorry,
I understand that entirely, Mr. McKenzie. Your problem is that the opening sentence phrase of paragraph 2, is where it has entered into an applicable treaty for the mutual enforcement of judgments. And this is, the Riad Convention is undoubtedly a treaty for the mutual enforcement of judgments, even though what you're seeking at this stage is only recognition. So once you look at the treaty, you're stuck with the words of Article 30E, unless somehow I've got some liberty under the final sentence to ignore it.
Well, we certainly argue that you do have liberty to apply your own discretion, given the clear and express wording of Article 30. But given that there are aspects of the treaty that have been ignored essentially by the appeals court in the DIFC, where they say that by virtue of their reasoning, the Riad Convention does not automatically apply within the DIFC, we would argue that there is obviously discretion of the court to apply what provisions of the Riad Convention it wants to treat as mandatory, and they're compelled under Article 24 to apply. We would argue that that is from only in relation to those provisions dealing with enforcement, not recognition. And if you add that with the wording of Article 30, or the last sentence of Article 30, that would seem to reinforce that position, which is that there is an inherent discretion, even when you are dealing with matters of enforcement, that permits the DIFC court to apply its own rules in this case.
Yes. Is there anything else you want to add on that point?
Not for the time being, but I may want to come back to it later in the context of the purpose of the convention itself.
Well, on the face of it, you see, on the face of it, I'm against you on this. It just seems to me your position is not arguable on a proper application of the statute. When the DIFC court law says in terms this is part of DIFC law, that's the difference between this case and what the Court of Appeal was saying in Lakil and whatever it's called. So I think for the rest of your submissions, you need to proceed on the basis that I can't recognise the judgment unless you can persuade me that the dispute is not the subject of a case being heard by the courts of the requested party. I can see there's potentially room for an argument that it's not being heard because it's stayed. But I have bound to say I have difficulty with that as an idea, albeit there's an argument perhaps to be had.
Well,
I don't know if you're planning to take that point or whether now I've suggested it to you, you want to take it.
Well, I think there's 2 points arising out of this, but I'll deal with the stayed point in a minute. From our perspective, the DIFC court has laid down a clear authority, it was in the Siwa case, which recognises the distinction between enforcement and recognition.
Yeah, I understand that. I've got that point, don't worry.
Yeah, but so we would ask the court to obviously look through that specific lens when reading into Article 30 and indeed reading into Article 24.2. But you're right in the sense, and this was a point we were going to come to later in the context of the final and binding nature of the court. But I'll jump ahead to that point now.
Well, can I help you on that? Because my understanding of the rules of private international law in England and in the DIFC is that a judgment which is subject to appeal is still final and conclusive on the merits. End of point. So you've got a final. So you've got a final and conclusive judgment of the Court of Appeal, but what you've got is an appeal pending, which is currently stayed because of a bankruptcy order of some kind which has been made, which is likely to lead but has not yet led to liquidation. That's my understanding, a formal, what we would think of as a formal winding up order.
Liquidation or re-engagement with the creditors, I think both are
but indeed, yes, exactly.
Restructuring of the debt. Yeah.
They have to decide whether they've said this company is insolvent, and the question is, do we try and come to some accommodation between creditors, or do we actually wind it up and just have pari passu distribution? That's what it amounts to, isn't it?
Essentially, yes.
And again, just to help you to focus on your submissions. The question which arises from my perspective, which I don't think either party has addressed, is what is actually the impact of such a decree or order in Kuwait in other jurisdictions, bearing in mind the usual position that when a company is put into liquidation in one jurisdiction, that impacts on the assets that it can deal with that are within the jurisdiction. But if there are assets in another jurisdiction, one often has to go to that jurisdiction and take out and apply for the company to wind up there in a subsidiary liquidation that takes place alongside the main liquidation. I don't use the correct technical expressions, but that's broadly the picture. And I would like you to address me on all of that, if you think that's in any way relevant.
Well, if I can do it in reverse and take each point in that order, because it is a point that we did look at in the context of the DIFC insolvency law.
Yes.
Schedule 4 makes it very clear that an application has to be made. And of course, the defendants have not made an application, nor are arguably the defendants empowered to make an application. If indeed trustees have or will be appointed. I understand they haven't been appointed. But in order for their supposed automatic stay to take effect in the DIFC under the insolvency law of the DIFC, an application needs to be made with respect to that. And then once that test and application has been heard, then a stay is possible.
And just stop you there. When you say an application has to be made in respect of that, what do you mean? You mean an application for what?
So, as I understand how the solvency law is supposed to work in practice, is that the trustees in bankruptcy are, once appointed, are to apply to the jurisdiction in which proceedings are pending to register the bankruptcy proceedings in that, or have those proceedings recognised is probably a more accurate term. And upon that application succeeding, then any proceedings in that jurisdiction would be stayed.
Yes.
And our position would be that the defendant cannot argue that the proceedings should not continue on the basis the defendant is in bankruptcy in Kuwait. They would need to bring a bankruptcy order recognised in the DIFC courts. And if such an order is obtained, present proceedings could in theory be stayed. But that is not the case as things currently stand.
Yes, I mean, all of this came up in the context of quite major litigation either this year or last year in relation to what was going on in Abu Dhabi in relation to
AMC.
An offshoot of the healthcare.
Yes.
I can't remember what they were all called, but basically it was all about bank loans and guarantees. Do you know what I'm talking about, or am I? Yes, you do. Right.
No, we're aware. We're actually involved in those proceedings down in Abu Dhabi with respect to the bankruptcy around NMC itself.
Yes. It was company. It wasn't NMC I'm talking about. It was related companies.
It was related entities within the umbrella. Yeah.
Okay. Yeah. All right.
But you're absolutely correct, Your Honour, that the application had to be made. The bankruptcy order had to be recognised in the ADGM courts in order for, and these proceedings were ongoing in England, as I understand it, in order for that to have effect, basically springboard from that order into a stay of proceedings in the ADGM itself.
Yeah. All right.
If I can go back to the point that Your Honour made with respect to the case being heard, to the wording of Article 30E, from our perspective, the appeal has not been stayed. It's the execution file that has been stayed, that was extended from the appeal judgment. So the Court of Appeal judgment is, as per Kuwaiti law, is final, it's binding and is enforceable. Our client has taken steps to enforce, and those proceedings have been stayed in relation to the enforcement. The appeal itself is also essentially on hold to a certain extent, given the bankruptcy proceedings. It's yet to be. Sorry.
Is it or isn't it? I mean, I understand your arguments about final conclusive on the merits. Doesn't matter whether it's the subject of appeal or not. But as to exactly what's happening to the appeal now, it was pending for a long time and nothing was happening. Execution of the Court of Appeal judgment has been stayed, but is the appeal itself to the Cassation, however pronounce it, court, is that stayed or isn't it?
I don't think we know for certain. If you just give me 2 seconds, Your Honour.
Well, it's a question really of what appears on the evidence as well as what you're submitting.
Apologies, Your Honour. I just wanted to confer. From our perspective, we don't have confirmation as to whether or not the appeal itself has been stayed or is proceeding. The last update we received was that in the judge's chambers, it was essentially still to be debated as to whether or not the appeal should go ahead, but no judgment or determination perhaps has been made on that. Mr. Yates may be able to shed some additional light on his clients as the actions obviously being brought by his clients as to whether or not the proceedings have progressed.
The question is not simply what you tell me on instructions, but what actually appears on the evidence. I'm not clear whether anybody has said in their evidence what the position is. What does Sharina 2 say, which is supposedly the most up-to-date position, isn't it?
I believe so.
Well, I'm looking at page 615 and paragraphs 19 through to 22. We are advised that Kuwaiti enforcement proceedings described as temporarily stayed are unlikely to be resumed. So there's no question that the enforcement proceedings are stayed.
Yes.
But what I'm unclear about is whether the appeal itself is stayed.
So if we turn to page 78, which is paragraph 17 of my third witness statement.
Yes. Which paragraph?
Sorry, paragraph 17.
Thank you.
The last word I think we have on the status of the appeal to the Court of Cassation is that it has not been set down for session.
That's back in June. You're saying the Court of Appeal judgment is capable of enforcement, but we know that's no longer the position.
Well, it is still a position in the sense that it is capable of enforcement. It's just the enforcement has been put on hold pending the outcome of the bankruptcy. So,
that may be semantics, Mr. McKenzie. It may be. I mean, if it's stayed, you can't actually enforce it, even if in its own status it is capable of being enforced. it can't actually be enforced at the moment because execution proceedings are stayed.
Well, execution proceedings are stayed in Kuwait, but that was
Yes. Yeah.
The status of the judgment itself, and I appreciate we're now splitting hairs, but the status of the judgment, the Court of Appeal judgment, has not been affected everywhere in the world against all assets that the defendants may hold. It has only been stayed for execution, so it's still final and binding and enforceable as a matter of Kuwaiti law. It's just that the enforcement proceedings that were ongoing and had been granted, because as per paragraph 17, the defendants tried to prevent enforcement by virtue of the appeal to the Court of Cassation. That position was rejected by the Kuwaiti courts. So it isn't by virtue of the fact that the court is still hearing the matter with respect to the appeal judgment. And this is just pulling us back to Article 30. Our position is that the merits of the case, the merits of the Court of Appeal, are not being heard by the Kuwaiti courts as per Article 30E. The case is not being heard by the courts, and it hasn't actually been heard for over 2 years. And even by virtue of the fact that under Kuwaiti law, the aspects of the case that will be heard are purely procedural, they're not matters on the merits, then ultimately the Court of Appeal's judgment, its sanctity, if you will, is maintained. And we could take that judgment and try and enforce it in other jurisdictions. It would be for the defendant, and bearing in mind we're only talking about recognition here, but it would be for the defendant to then bring an order of bankruptcy issued by the Kuwaiti courts to prevent that enforcement. One has to follow the other. They can't just say, well, we've got enforcement proceedings in Kuwait and that affects all assets elsewhere situated in every jurisdiction.
Yes.
Would Your Honour want to be addressed on matters of common law and the application of that?
In which particular area?
Well, in the context of the defendant's position that if the Riyadh Convention doesn't apply, then as matters of common law, the judgment cannot be recognised, although arguably they say enforced in the DIFC. We say that's not a starter for 10. I don't want to bore Your Honour with all the reasons why.
I'm perfectly persuaded at present, subject to anything Mr. Yates wants to say, that the Court of Appeal judgment is final and conclusive on the merits, on the face of it, so that the existence of the appeal in the first place wouldn't have stopped you applying for recognition. I think that's all you need for the moment. And if Mr. Yates wants to persuade me otherwise, he can do that, and you can reply in due course.
Yes. In which case, given that it seems to be that the only contentious point between the parties is the Riyadh Convention and its application, perhaps I can pause and let Mr. Yates respond to what's been discussed, unless there's any other points that Your Honour wishes to be heard on at this point in time.
Well, I'm still troubled by the whole of the bankruptcy thing because the evidence is unclear. There's a discretionary point which arises here. If the position is unclear, and it may be that applications have to be made in relation to insolvency in the DIFC, there would presumably be merit in the suggestion that you should receive permission to amend, but that any question of actual recognition should await the outcome of whatever's going to happen in Kuwait. It looks as though things are going to move there in due course, either towards a winding up or an accommodation of creditors. And then the court would have to look at the position in the round in the context of actually deciding whether or not to recognise the judgment. Or come to that, perhaps enforce it. And there may be a difference between the two, as you say. But that's for another day, you say.
We do say, because really the test to amend here is that the prospects of success. We argue that the prospects of
no realistic prospect of success. Yeah, no, I understand.
Yeah.
Yes.
And that test, although, sorry.
Yeah, no, I've got that point. So yeah. Shall I hear Mr. Yates on about the Riyadh Convention, which I think is probably the key question for today?
Your Honour, thank you. It's right to say from the outset that we do agree that the relevant test for the real prospects of success is that set out in the Oman insurance case. So that's the starting point. What we would say is that the prejudice isn't really something you need to take into account, because unless real prospects of success are established, you needn't then go on to consider anything else.
I'm not interested in prejudice at present.
In relation to the Riyadh Convention, you'll see in the skeleton argument the logic by which the defendant says that those parts of the Riyadh Convention relating to the recognition and enforcement judgments do apply despite the Lahala case. And that's because Lahala, and I think you're with me on that, but it's in brief, because Lahala just gives the starting point that the UAE federal laws are not part of the free zone as a result of Article 3.2, and nor can they be brought in, or they deemed to be part as a result of Article 5. So that gives you your premise. But then the question is, has the free zone done anything to bring in the application of those provisions? And we say 24.2 does precisely that. Interestingly, it doesn't bring in the federal provisions that bring the treaties into part of domestic law. It actually brings the treaties directly. It says you shall conform with the treaty provisions. We say that they're there. And the other relevant point is that enforcement has an enforceability, doesn't have any relevance insofar as the Riyadh provisions are concerned. In relation to recognition, it may be that they would be relevant for the purposes of enforcement because there's a different section, and the wording suggests that enforceability is required in the originating state in order for it to be enforceable within the target state. But we're talking only here about recognition, and the only test that the only thing that the defendant needs to satisfy you of is that, in accordance with 30E, that there are proceedings pending before other courts in the originating state, and that those proceedings commenced before the application was made, and those are satisfied. The enforceability.
Can I stop you there, Mr. Yates? We're looking at an English translation, not
yes.
The original is undoubtedly Arabic, I'm sure, and I'm not quite sure whether the status of the translation is, but on the wording that is here, and indeed if you go online to look it up, you get, if the dispute is also the subject of case being heard.
Being heard.
And the argument that appeared to me, and which I think Mr. Mackenzie sought to embrace, was whether or not what you have currently in Kuwait is a case that is, quote, being heard or not, which raises the question of the status of the appeal.
Yes, well, there are various degrees of interpretation that you could apply. There's a literal, is it being heard now as we speak, or is it being heard at some point, or has it been dismissed? Is it no longer being heard in a definitive way that can't be reversed? It is in the process of somewhere between the defendant applying for it and the Court of Cassation giving its decision. But we would say it doesn't matter if it's being stayed, so long as it hasn't been permanently dismissed. It is being heard. It's still before the courts in that sense, and so that would be satisfied. The emphasis.
Understand that point. So you say it wouldn't matter if it was stayed anyway, but is the appeal in fact stayed, or is it merely execution of the Court of Appeal judgment that's been stayed?
Well, the execution
of
the
effect. I mean, I'm not clear on the evidence as to what it said the effect of the institution of bankruptcy proceedings, whatever one wants to call it, actually had. I don't think anybody has said, I don't think there's any evidence in front of me that actually the appeal is stayed per se.
No,
is that right?
There isn't any evidence to that effect. I don't have any instructions to that effect, although I take into account what Your Honour says about oral instructions being a lesser form of evidence than what you can see on paper.
Not evidence at all.
But of course,
but I would proceed on that basis if instructions were given that I was confident of, and you were confident of, or indeed if there was agreement in instructions from both sides. But
Your Honour, the reality is
this is a case where the parties have got across each other so much that I'm not likely to take instructions from one party as representing the truth unless there's agreement or very good reason to do so. So I have to think, I think, on the basis simply of the evidence that's in front of me, which, unless anybody's going to point me to something which says so, I don't think the evidence shows that the Court of Appeal decision has, that the appeal to the Court of Cassation has been stayed as yet.
Your Honour, that's right. There isn't any evidence, and part of the reason for that is because the focus has, since the application to amend was made, been on the Court of Appeal decision, because that's the decision upon which the claimant now relies. But
yes.
But Your Honour, that's right. There is nothing before you to suggest that the Court of Cassation appeal is otherwise than on foot. And if that is something that you're satisfied of, then the final and conclusive test isn't required. It's relevant only for the common law position. And the enforceability question is again not relevant, because even under the convention, the claimant's application is currently for the recognition, not for the enforcement. So arguably, if you're satisfied on those points, you don't need to hear anything else. But of course, there are other arguments on the subsidiary points if you want to hear them.
Well, I think I'd quite like to hear what you do say about the impact of the bankruptcy proceedings. As I say, I don't. If you want to simply rest your case, so to speak, on the basis that the Riyadh Convention says can't enforce it, then and say, well, that renders the case hopeless. I'm sorry.
Yes.
Sorry. I've used the expression enforce when I should recognise.
Recognise, yeah. And although, of course, Your Honour, we're mindful of Justice Wayne Martin's indication of his view in Fal Oil that recognition is inherently a part of enforcement, because you have to recognise before you enforce. So his view was he plugged that gap that might be referenced in the JAL Article 7, where it suggested that it relates only to enforcement and not to recognition. He said it relates to both. But yes, that's the point. The simple version of the case is that if Riyadh applies, the claimant cannot satisfy that it has real prospects of success, because the court is prevented from that recognition. If it didn't apply, there's then an argument as to whether the waterfall provisions apply such that the common law applies. Now, the decision that was given to us about an hour before, 2 hours before the hearing, is an instance where there was an attempt to put malicious prosecution as a tort into the part of DIFC law using the waterfall provisions. But the court decided there that this relates to which law applies generally, rather than filling in gaps of content. So because the DIFC has a law of obligations, just because it doesn't have a particular tort, you don't go looking
You can't create new causes of action.
Exactly. Whereas, as Your Honour is aware, the decision in which you were involved, the decision in Lural indicated that there was a gap, and that when you have a gap, you have to go to the common law. There's just no law at all as to what the provisions are that you can that you apply. Of course, that didn't involve a Riyadh Convention point, because you were dealing with an Abu Dhabi court decision where the courts had accepted jurisdiction despite an exclusive DIFC court provision. So the Riyadh question didn't come up. But in that case, there was a clear indication that if there is an absence of law, then you do, through the waterfall provisions, go to the common law. We're not getting there today, but it does mean that the application of the Riyadh Conventions is essentially dispositive. You no longer need to consider what is enforceable and whether it's enforceable, and whether enforceability, for instance, accepts final and conclusive judgment, or the final and conclusive status of the Court of Appeal award. There are arguments on that. Going to Dicey, they may not be something that would find favour with you, but we say you don't need to go that far now if this can be disposed of on the basis of Riyadh. The other point that I'd say briefly is that what's emerged from the skeleton argument is that the claimant has clearly been proceeding on the misapprehension that all they had to do in order to obtain recognition was to satisfy the jurisdictional requirements. Because, and you can see that from the arguments that they've put, the way that they've put the points, that so long as they satisfy Article 24, then they're home and dry, and that there are no tests. Which questions why they put so much emphasis on enforceability, but it seems that they've missed that point of final and conclusive, and removed it from the amended claim. It no longer forms part of the amended claim. It no longer forms part of the first amended witness statement. And in fact, what the claimant in its skeleton argument now says is that they don't need it. They don't need it to be final and conclusive. So up until now, they've, this is in the bundle, page 1008. There is no
paragraph.
Yeah, the paragraph reference in the skeleton argument is paragraph 23.3. 23.3, the claimant says there is no requirement for a judgment to be final and binding for it to be recognised pursuant to DIFC law. The only requirements for a judgment to be recognised are those in Article 5A1E of the JAL and Article 24 of the DIFC court law. In fact, they go so far as to say in paragraph 23.2 that we are the ones conflating the requirements of recognition with those of enforcement. They believe that you need to have full and final status in order for a judgment to be enforced, but not to be recognised. So they've...
That just doesn't make any sense, does it?
It doesn't, and I think that's why it explains to some extent why we've arrived where we are. That, given the history, of course, where the claim was started on the basis that the claimant believed it possessed a final Court of Cassation decision, which turned out to be an interim order. The Court of Appeal decision couldn't be enforced, so they then scrambled to look at another cause of action and rested on the Court of Appeal decision. So this explains in some way why the claimant's position has changed. But even if they'd brought it on the basis of being possessed of a...
I'm getting interference, Mr. Yates. I don't know whether it's at your end or...
No, I'm getting it as well, but it's not here. There's
Okay,
a silence. Right. The so this to some extent explains
Can
why.
you just take me to the... We have an amended claim form, don't we? But not is there an amended, anything beyond the amended claim form?
Yes, there's an amended AWM1.
Yeah, what I'm interested in is the way they're putting the case in their claim now.
The way that the claim is now...
It was put on the basis of being fully executable.
Yes, that's right. There are several grounds in support of why the claim has reasonable prospect of success. But although they are set out in AWM 1, in fact, as far as AWM 3 as well, most of them relate only to jurisdiction. The only other point that is raised is at enforceability. So they say it's fully enforceable, even though it's stayed, it's fully enforceable. And that's the argument they put forward for having real prospects of success. Of course, if to the extent that that's irrelevant, once you apply the RIAD provisions, then they're not putting any basis in the amended claim for any prospects of success at all. So the amended claim form you can see on page 721 of the bundle. It starts at, sorry, page 58.
59 I'm looking at, yeah, 58, 59. Yeah.
Yes, 58, 59.
Yeah.
So you can see the amendments that have made there. They've removed references to the judgment being final and binding. Then the amended first witness statement is what we see in the bundle at page 62.
Yeah.
And the same changes have been put through there. So it's now the executable status of the judgment that is referenced. The only time that the executability of a judgment becomes relevant is in the provisions that relate to DIFC court awards being enforced in Dubai and vice versa. Then there's a requirement that there's enforceability, but it doesn't feature in, and that's under JAL Article 7, but it doesn't feature in Riyadh Convention, and it's in relation to recognition, and it's not relevant for the common law purposes either. So as far as the bankruptcy effect or the relevance of bankruptcy, if we were under the English common law provisions and we saw that the judgment was being treated as final and executable despite the presence or the existence of an appeal in a superior court, there are two questions that arise. One is whether insolvency has any relevance at all, because it's an administrative process that's going on in a different jurisdiction, and it's not, of course, the judgment itself that's being enforced in the target jurisdiction. It's serving as evidence of an obligation, which the courts in the target jurisdiction effectively honour and will create a fresh judgment in respect of. And that's something which the DIFC courts have looked at and decided as well. You might seek recognition for ulterior purposes. It may be an issue estoppel reason rather than, and so you may not need a judgment, you may not want one. But when it comes to insolvency, arguably it doesn't have any bearing. Cross-border insolvency doesn't have any bearing on the on whether or not the judgment is final and conclusive. However, it may have an effect on the court's discretion, in the same way that a stay can have an effect on the court's discretion. So the court may, for instance, decide to stay the application for recognition and enforcement pending the outcome of proceedings that are ongoing elsewhere, where a stay has been imposed. Similarly, when it comes to bankruptcy, we say that may be a relevant factor in the exercise of your discretion as to whether to grant the recognition or the enforcement, because the court would be conscious that as an issue of comity, there may be significant prejudice caused to other creditors. And so you may stay the matter, or you may, for instance, enforce, but make it so you may award the recognition and enforce, but preserve somehow the rights of those who may be affected by either the decision or the bankruptcy.
That's what I had a discussion with Mr. Mackenzie, but what you might well do is recognise the judgment, because it is no more than recognising an obligation that has been found to exist by another court, but stay any question of execution until the assets position was sorted out by reference either to the insolvency proceedings in Kuwait or any local insolvency proceedings that might be taken in the DIFC. because any court would be reluctant to let one creditor steal a march on the others by forging ahead in a different jurisdiction, because there are some assets there. I don't know that we have any evidence as to whether there are any assets in this in the DIFC anyway, or whether this is to be imported into Dubai or wherever. But whichever it is, the court would be likely to want to know what the trustees in bankruptcy, the liquidator, whoever it might be, was intending to do in relation to foreign assets.
Your Honour, yes, I agree. That's what one would expect.
You can't have one creditor jumping ahead of the others when they're when it's known that the company is actually insolvent and there have been insolvency proceedings instituted somewhere. I mean, that just doesn't make sense.
Yeah.
A creditor can jump in before any company is declared insolvent. That's one thing, and thus get a judgment and perhaps even execute before anybody else turns up and insolvency proceedings are commenced. But once insolvency proceedings are started, you've got to obey the rules, haven't you?
Your Honour, yes. Otherwise, you might expect something in the future that's going to be equally chaotic when it comes to your own jurisdiction, and that's right. And I think there was an indication in correspondence earlier from the claimant that its intention is not to enforce in the DIFC, but to take the judgment to England and do something to England. But but interestingly, there was a request for recognition and enforcement originally. That was the original claim. That has changed because we say the claimant was under the misapprehension that there was a lesser test, there were lesser qualifications or issues to be satisfied in obtaining a recognition of the judgment. And so that's why they switched. Of course, there are still things that they need to satisfy. They may have satisfied them if they'd gone through that route, but have been the subject to a stay as far as the execution is concerned. But in this case, again, we say you don't need to go that far because Riyadh is fairly comprehensive. It has different provisions relating to recognition specifically from enforcement, but on the basis of the status of the Court of Cassation appeal in Kuwait, the court's obligation, it's mandatory, is not to recognise. There would be different questions if we didn't have Riyadh or it wasn't applying, but it's there, and we say it's effective.
Then just tell me what's. I'm looking now not just at today, but at the future. So if the company is put into liquidation formally in a month or two's time, or indeed if an accommodation is reached of sometimes a reorganization, what one would think of as a creditor's arrangement of some kind.
Yes.
Well, I suppose actually that if there was creditor's arrangement of some kind, then no doubt the claimants here would be bound by it. But what I was trying to work out was if there was a possibility that at some stage in the future, the case is not being heard in any sense of the word in Kuwait, because the company has gone into insolvency, but there has been no application in this jurisdiction for a subsidiary insolvency proceeding, liquidation, or whatever. What then happens? I mean, putting it bluntly, supposing I simply refuse leave on the basis this has no prospect of success because of the terms of the Riyadh Convention and the fact there is currently a case being heard by the courts in Kuwait.
Yeah, where's the justice? Yes.
All right, can they come back again? Well, perhaps they can. They can come back in due course if that proceeding, that situation changes. But is it ever actually, is that ever actually going to happen?
Well, in the latest evidence you have from the claimant, they say they've registered, which is what they should do. They've registered the Court of Appeal decision with the liquidator. So
Where do they say that? All right, we'll come back to it, but
I'll find that. But we say they've registered that because they use the word final for the only instance they use the word final, and I think it's in the skeleton argument. So it's there. But they've registered, so their interests are protected there. If anything changes in Q8, for instance, if something happens to the Court of Cassation proceedings, if they're dismissed, there may be implications. Even if there's an articulated stay, then we say it wouldn't have any effect on the Riyadh provisions. But if it was dismissed, then the question of whether they could have recognition and enforcement may not change, because for enforcement under Riyadh, it still needs to be executable, which they wouldn't have. So whilst ever things remain with the liquidator, they're protected, but they would have difficulty bringing anything based on the cassation decision or the Court of Appeal decision because of the Riyadh Convention. Once the distribution has been made or a settlement has been agreed, then we would have a payment defense that it had been paid, so there was no ability to enforce the judgment. I think what's happened here is there isn't significant injustice being done to the claimant, because the claimant's claim was brought under the misapprehension that it had a final and conclusive decision, which it didn't. And so it never had a claim. Its original claim is actually not there, because the claimant was told, you have a handful of beans, and once they accepted that, they amended the nature of the claim. What they can do with the Court of Appeal decision that they now have, given that it stayed, is, I suggest, limited, and they might not have brought the claim in the first place. But with that, they can make that decision if they can somehow remedy it. But then they would be to be able to act on the Court of Appeal stayed judgment, they would need something to happen to the cassation case. My understanding is that nothing will happen. The stay will remain until either there's a voluntary arrangement or there's a court-imposed arrangement with the creditors, or there's a liquidation. So I don't think there is likely to be a significant change. The focus for the claimants is, and always ought to be, what's happening in Q8, not trying to steal a march effectively on other creditors in different jurisdictions.
You've just said a number of times, but without, I think, any evidence that there's a stay of the appeal.
Sorry, the stay of the enforcement. The stay of the enforcement of the Court of Appeal.
I understand that, stay of the enforcement. Now, one last question, and that is, who are you representing today?
I'm representing the defendant today.
Yes, not the liquidator, not the trustees and bankruptcy or anybody else.
No. And that is an issue that arose when I think the first correspondence said that the liquidator was the relevant party to be addressed in relation to claims. But it's questionable whether that has relevance outside of the jurisdiction of Q8, because the laws of Q8 don't apply here unless we adopt them, and they don't apply in the DIFC unless they adopt them. It may be convention that through a direct order of the court that all claims must go and be centralized through the liquidator, but that must relate to domestic litigation.
That would depend on the law of the place of incorporation of the relevant defendant, because if by the law of the place where the company is registered, the directors no longer have authority to act for it, and only the liquidator does, then if that was the position in the Kuwait, about which I have no evidence at all,
No, I don't have.
Then what are you doing here, Mr. Yates? It's all very helpful and interesting, but what are you doing here?
Yes. Well, as it would, the position when instructions were received, I'm not sure whether the liquidator had been appointed. The liquidation, the appointment of the liquidator came partway through. I haven't received any direct communication or instructions to the effect that it's otherwise, nor has the client sent anything directly to say that we no longer have authority. Aside from that, we say that
this may be just a diversion, but I just want to be clear about all this. Can you just show me the evidence as to what is the actual decree that has been made in Kuwait in relation to the insolvency of the defendant?
Yes, I believe it's attached to the third. Sorry, to the first witness statement of the defendant's witness, but it may take me a short while to locate it.
I mean, at 587, on the 1st of May, appears a document which talks about the suspension of execution proceedings.
Yes, this is the order from the Court of Appeal confirming that, well, from the execution judge.
Yes.
Confirming that execution proceedings filed against the company shall be suspended. And that is the document which I think evidences an agreed position that enforcement proceedings have been stayed. But that's not the piece of paper that tells you about the insolvency. But the insolvency isn't disputed. I think that, again, is something that both parties have accepted. That.
Well, I understand, but if you look at that document, underneath the underlined passage, it tells you that on the 18th of June 2019, the plenary court rendered a judgment in claim 380-2019 for bankruptcy of the applicant company.
Yes, that's what you'd like to see.
Well,
I think it's in there. I think it's attached.
Oh dear. Oh, right.
I think it's attached to the first witness statement. Let me find it. I understand exhibit MS4.
Thank you.
MS4 we can find on. It's in the first witness. It's actually the first witness statement, MS4. Apologies.
You see, what is said in Sharina 1, paragraphs 35 onwards, is that it was a bankruptcy order was made, which was confirmed by the Kuwaiti Cassation Court in March 2023. That's paragraph 35 and 37, which explains why we have a 2019 original bankruptcy, and it goes all the way up to the Court of Cassation. So there's finality about the bankruptcy as of March or 15th of May. Appears to be the final date, doesn't it? Paragraph 37.
Yes, Your Honour.
Yeah. But what does that mean is what I really want to know.
Well, there was a challenge by the defendant resisting the insolvency.
What's the nature of what has been said? It sounds from my reading as though it's a declaration of bankruptcy, but without appointment as such of liquidators, trustees in bankruptcy or anything equivalent. I mean, it goes really to your status as to why you should be here at all.
MS4
Yeah.
is the document I've been referred to, and I'm seeing it on the
page.
.335 of the bundle has is
335.
335. Actually, the decision is 341. So the court adjudicated that by accepting the appeal and joining intervention in form and in the subject of the 5 appeals, by cancelling the appeal judgment and adjudicating by rejecting the lawsuit and objecting the appellees in their capacity from the 1st to the 7th. Well,
I'm looking, I'm on the online trying to get 341. It's taking a long time to come through. Do you mean 341?
That was the final page of MS2. The first page is 249.
No, well, it's just taking time to get there.
Apologies. The details of the order relating to the bankruptcy wasn't a primary focus, but it is something I've looked at. But I'd have to refresh my memory to be able to say what it says.
Well, there's definite reference in the order at page page 587 to a bankruptcy trustee. And this is the 1st of May. Which makes me suspect that you ought to be taking your instructions from the bankruptcy trustee rather than whoever it is you are taking instructions from. Anyway, there it is. Is there anything else you can help me with at this stage, Mr. Yates?
Your Honour, I don't think so.
No, all right. Thank you very much. I'm sorry we've had a bit of a devious route around the houses, but trying to work out what may make sense for the economics of this in the future, as opposed to what may happen today. is something that I'm concerned with. Anyway, thank you very much. Mr. Mackenzie.
Thank you, Your Honour. Sorry, am I on mute? I just wanted to pick up on a few things that Mr. Yates covered, because again, I think we're now conflating back into the issues of what the test for amendment is, what the test for recognition is, and what the test for enforcement is. So, as I said earlier, the claimant is seeking amendment of its claim. The test for that amendment is set out clearly in the Omani case, which talks about a real prospect of success. Mr. Yates had said previously that that's not disputed between the parties, and that is correct. Where it became a bit muddled was this concept of, and he mentioned it several times throughout his oral submissions, that we have advanced that the judgment is final and binding and indeed conclusive, which he maintains is not the case. But in actual fact, the law that he himself relies on, English common law, actually confirms, and I think Your Honour said earlier that he is convinced on this point, that a Court of Appeal judgment is final and binding and conclusive. So with respect to the amendment, the element of the amendment test that deals with success, the issues with respect to the binding and final and conclusive elements of the Court of Appeal judgment have been confirmed by case law. And that's the Murex against Freeman case, the House of Lords case, which said that a judgment from a Court of Appeal is essentially still final, binding and conclusive, regardless of the fact that it may be subject to appeal. So that is clear law in relation to that issue. So in terms of the success element of our claim, we would say we've met the test in terms of that point of recognition. There's obviously a lot of case law around, and Oman Insurance references it with respect to conducting a mini trial with respect to the success element. And again, this is where we get into this muddy ground or grey area with respect to recognition and enforcement. And we very much clearly state that this is a recognition application. If the stay of bankruptcy was to apply, it would only apply if we were to bring an application to enforce. The other aspect of this is obviously the Riyadh Convention, and I do appreciate, Your Honour, your comments and guidance with respect to the wording of Article 30E. If we can go back to that, that's on page 942. So the test for recognition, as we've said earlier, before we look at Article 30, is we maintain is Article 24(1)(a, that pursuant to Article 7.4, and for that you must read 7.6 of the Judicial Authorities Law, the court has at first instance the jurisdiction to ratify, and it makes a clear distinction. It doesn't say ratify and enforce. It says ratify any judgment, order, award of any recognised foreign court. There is no dispute, I believe, before this court that the Kuwaiti courts are not a recognised foreign court. So as far as the test under Article 24(1)(a) is concerned, that has been met. The difficulty that we encounter is with respect to Article 2, where the UE court has entered into an applicable treaty for the mutual enforcement of judgments, orders, awards. The court must give, for court of first instance, shall comply with the terms of such treaty. Now, we would make the argument, and perhaps Your Honour isn't persuaded by it, that when you have met the test under Article 24(1), you do not have to proceed to Article 24(2), and the characterisation of Article 24(2) is purely in relation to enforcement, not recognition. Now, I appreciate you can take the entire Riyadh Treaty as dealing with all of those issues, but from our perspective, the framers would have included the concept of enforcement in Article 24(1) if they meant for it to be treated as one and the same. They would not have distinguished the two concepts, nor indeed would they have distinguished the two concepts in the Siwa case and other authorities where there has been this clear distinction between the two concepts. So let's turn to Article 30. E, if the dispute is also the subject of a case being heard. The operative part of that sentence is obviously that it is being heard. Now, the only evidence before the court at the moment as to the status, and I used the break to double check this, the only evidence before the court is paragraph 17 of my second witness statement, which deals with the issue, which confirms that the court, and apologies, I'm just getting back to page number. It's page number 78 of the bundle.
Yeah.
it says that on the 24th of August 2021, the defendant challenged the CFI judgment and the Court of Appeal judgment before the Court of Cassation. That was back in 2021. The defendant appeal is on purely procedural grounds, so not as to the merits. The defendant's appeal was served on the claimant on the 24th of August 2021 and has been set for session before the Court of Cassation, notwithstanding the significant passage of nearly 2 years. Now, this is where we would argue a number of things. One, that there's been a 2-year delay. The case is actually set before the court, but is not currently being heard by the court, nor has the court actually accepted to hear the case. There's no evidence before you, Your Honour, that confirms the judge at cassation, or the judges at cassation, have confirmed the fact that the case can proceed. In fact, the court judicial system in Kuwait have sent the opposite message, which is the Court of Appeal execution should proceed. Obviously, that's now subject to the bankruptcy proceedings, but that's a separate and distinct issue. The evidence is that the Court of Cassation case is not active, it is not being heard, and 2 years have passed since it was lodged. Now, another aspect to this that we wanted to raise, and I appreciate this authority isn't before Your Honour, but the Riyadh Convention is a creature of public international and private law. And there are a number of cases at international law which deal with the concept of delay and disruption to proceedings. There's one specific case, which is the Manchester Securities against Poland case. And it was to do with the exhaustion of local remedies with respect to bringing essentially a bilateral investment treaty action. And in that instance, the court ruled that where there is a precondition to go to domestic remedies, when this would be evidently futile or unreasonable, such as when the claim relates to excessive delays in judicial proceedings, or when there is evidence of a manifestly defective judicial or administrative system, then that requirement to effectively adhere to the domestic avenues, if you will, can be dispensed with. Our position would be then for twofold. One, that the case is not being heard by the Court of Cassation, and we have had a 2-year period. Even in Kuwait, where justice perhaps proceeds a little bit slower to other GCC states, it is still not common for a court for an action of this nature to take 2 years before the Court of Cassation actually hears, determines whether it can actually hear the case. It isn't a question of saying, yes, we are going to hear it, and it's taken us 2 years to bring the proceedings. There is no evidence to state that they have even entertained the appeal. It is still sitting essentially in judicial limbo. The second aspect, we would argue that if the Riyadh Convention is to apply, it is to apply in the context of public and private international law principles, which state that any delay, any considerable delay to the hearing of a matter should not prejudice a party essentially trying to enforce its rights with respect to a final binding and conclusive judgment. Now, I could see arguments that Mr. Yates could run with respect to, well, yes, but if you were enforcing this and trying to steal a march on the creditors, then that's a different story altogether. That mixes in the bankruptcy perspective, but it also mixes in an element of proactive action against the defendant. We are not advocating that at this stage. We are advocating just the right, which is afforded to us under Article 24(1), to recognise the judgment. Whether we bring an action to enforce is yet to be decided. I'll correct Mr. Yates slightly with respect to the assets in the DIFC. That is an issue that is to be determined. We have a good faith basis to believe that there are assets in the DIFC, which is why this jurisdiction is chosen. We also have a good faith basis to believe that there are assets elsewhere in the world. But that is all a matter for recognition, all a matter for enforcement, not recognition. The test for recognition, as I've said, is Oman insurance. It's real prospects of success. DIFC law recognizes the ability of the court to affect recognition. The test for enforcement and indeed the consequences of it are substantially different and would need to be considered, but we're not asking the court to consider that. Today's application is purely our right to amend. Whether or not we then have a right to seek enforcement would remain to be seen and argued over at a later date. And this is where we go back to Oman Insurance and the authorities in Swain and Hillman, where it said that there should not be a protracted debate and effectively a mini trial, as the court put it, with respect to the merits of the case. That can wait post the amendment. That's all I wanted to say with respect to the issues that Mr. Yates covered. I know we drifted into English common law. We still maintain that it is not relevant and practical to debate that at length, but I can, if Your Honour wishes to hear me on that, I can.
No, thank you. No, I don't. We had an interesting discussion, but it doesn't really impact on the matters I have to decide.
There was one final point, which was just to indicate to Your Honour the article under the bankruptcy law, which I referenced earlier, but I didn't reference the article, so my apologies. But this is DIFC law number 1 of 2019, and I believe it's Article 20, which specifies whether or not an automatic stay of the proceedings come into play, and that's only once recognition of foreign proceedings have taken place. Apologies, it's Article 20 of Schedule 4, just to be clear. Article 20, and apologies, I know Mr. Yates and yourself probably don't have it in front of you, but it says upon recognition of foreign proceedings, that's the foreign bankruptcy proceedings, that is a foreign main proceedings, commencement or continuation of individual actions or individual proceedings concerning the debtor's assets, rights, obligations, or liabilities is stayed. So as a matter of DIFC law and process and procedure, the bankruptcy proceedings would need to be brought here, but they would need to be brought by the trustees, which have also not been appointed in these proceedings. So from the claimant's perspective, we are left in judicial limbo while the proceedings in Kuwait don't progress, have not been heard, or are not currently being heard by the Court of Cassation. So we would argue that the Article 30E wording does not trigger. As far as the bankruptcy issue is in contention, then again, we maintain our first point, which is that is only applicable as and when we seek to enforce against assets in the DIFC. And it isn't a matter that needs to be debated by this court with respect to our amendment. And it isn't even a matter actually that we need to debate in terms of the recognition. And with that, Your Honour, unless I can be of any further assistance, I'll pause for questions if you have any.
No, I don't think so. Thank you very much. All right. I will give an extempore ruling now. I have before me an application on the part of the claimant for permission to amend the claim form. Whereas previously the claimant had been seeking recognition and enforcement of a judgment of the 24th of October 2021 of the Court of Cassation. What is now sought in the amendment is recognition of the judgment of the Court of Appeal in Kuwait, given on the 23rd of June 2021. At the time of the original claim form, it was the understanding of the DIFC lawyers acting for the claimant that the Court of Cassation in Kuwait had dismissed an appeal from that decision. But in fact, what had happened was that on the 17th of October 2021, the Cassation Court had rejected the defendant's application for a stay of execution of the Court of Appeal judgment. The appeal to the Court of Cassation remained in being, but nothing has happened in the 2 years since that time by way of any hearing of that appeal. The way that the matter is put, both in the proposed amendment and in an accompanying witness statement, is that the Court of Appeal judgment is a, open quote, fully executable judgment, close quote, whereas previously it had been said that the judgment was final and binding. Whether or not the former expression is intended as a shorthand for the latter is unknown. In my judgment, in accordance with ordinary principles of private international law, any judgment of a court, even if subject to appeal, can be final and binding and conclusive on the merits at that point. It constitutes res judicata, which is the essence of the point which matters for the purpose of enforcement. As I've already mentioned, the claimant is not seeking enforcement at this stage, but merely recognition of the judgment of the Court of Appeal, which is, as I see it, final and binding, but is not, as has been contended by the claimant, fully executable. This is because a stay of execution has been imposed in Kuwait. Whilst Mr. Mackenzie argues for the claimant that the status of the judgment remains unchanged, in other words, it is in itself a judgment which is capable of being executed, it is not now fully executable because the court has said that it is execution is to be stayed. The reasons for that essentially are I'm sorry, delete that. I'll start again now. So far as the appeal to the Court of Cassation is concerned, there is no evidence before this court that it has been stayed in itself. There is, moreover, no evidence that the appeal to the Court of Cassation has been dismissed. The result is that the claim is still pending in the Court of Cassation, despite nothing happening for over 2 years. It is wholly unclear from the evidence put before the court whether, in fact, the effect of bankruptcy proceedings, which have been confirmed by the Court of Cassation itself in March or May of this year, has the effect of either an automatic stay of the proceedings or whether there has been an order to that effect. It's in this context that I have to determine for the purposes only of the test in relation to amendment, which is whether or not a claim has a realistic prospect of success, what the effect of Article 24 of the DIFC Courts Law is. Article 24 provides for ratification of judgments and states that the Court of First Instance here has jurisdiction to ratify any judgment, order, or award of any recognized foreign court for the purposes of the enforcement thereof in the DIFC. there can't be any doubt that in this context, where the word, quote, enforcement, close quote, is being used, that is intended to cover the position of recognition as well, because the whole provision is relates to the ratification of any judgment, order, or award. In passing, I note that any judgment, order, or award must be subject to common law principles of it being final and binding, and that an interlocutory order of some kind, which did not determine matters on a final and binding basis, would not qualify for this purpose. The real issue here arises, however, in relation to Article 24, subparagraph 2, which reads as follows, quote, where the UAE has entered into an applicable treaty for the mutual enforcement of judgments, orders, or awards, the Court of First Instance shall comply with the terms of such treaty. The effect of that, as Mr. Yates submits for the defendant, is that if there is such an applicable treaty, its terms have to be applied by the DIFC court as a matter of DIFC domestic law. The court's law itself incorporates for these purposes the terms of any applicable treaty relating to the mutual enforcement of judgments, orders, or awards. I am in no doubt that the Riyadh Convention is an applicable treaty for such purposes, whilst it covers a number of matters, including service out of the jurisdiction and letters rogatory and the like. It also specifically covers recognition and enforcement. It is notable that recognition and enforcement are dealt with in different sections of the convention. Regardless of that, the fact is that the Court of First Instance must comply with the terms of a treaty, which is a treaty for the mutual enforcement of judgments, orders, and awards, and recognition is part of the overall process, a necessary preliminary to enforcement in any event. When one turns then to the terms of the Riyadh Convention, one finds that Article 30 says this, open quote, recognition of judgments shall be refused in the following cases, ... and then subparagraph little e, if the dispute is also the subject of a case being heard by the courts of the requested party, and the action has been brought before the courts of the requested party on a date preceding the presentation of the dispute to the court of the requesting party, close quote. There is a sentence which follows, to which I shall return in a moment. Leaving aside that sentence, however, the effect of Article 30 is, in my judgment, clear. The court is bound to refuse recognition of a judgment if the dispute is the subject of a case being heard in Kuwait, which began before the presentation of the matter to this court. There is no doubt that the proceedings in Kuwait preceded the matters here by a distance, as might well be expected in a case involving recognition of a judgment. The question is whether or not the case is, quote, being heard, close quote, by the courts of Kuwait. whilst I'm conscious that this is an English translation of an Arabic convention, in my mind, there is no doubt that if the case is in any sense pending in the foreign court, then it is, open quote, being heard, close quote, by the courts of the requested party. Until such time as any claim is dismissed, any action is concluded in Kuwait. Therefore, the case is being heard by those courts, whether stayed or not. Reliance was placed by Mr. Mackenzie for the claimants on the final sentence of Article 30, which states that, open quote, the judicial body examining the request for recognition in accordance with the text of this article may observe the rule of law in its own country, close quote. That does not, in my judgment, give this court any discretion to depart from the express words of Article 30, subparagraph E, which requires recognition to be refused in the circumstances there outlined. It therefore appears to me that on the face of the terms of the Riyadh Convention, as incorporated for these purposes by Article 24, subparagraph 2 of the court's law, that there is no realistic prospect of success in a claim for recognition of the judgment of the Kuwaiti Court of Appeal. That is quite sufficient for these purposes, whatever may be the position in the future, should the proceedings in Kuwait be concluded. There is, however, the additional complication which arises from the declaration of bankruptcy of the defendant in Kuwait. As it appears from a judgment of the Kuwaiti Court of 1st May 2023, a claim for bankruptcy was originally accepted on the 18th of June 2019, which involved the appointment of a bankruptcy trustee, and which has finally been upheld by the Court of Cassation. Reference is then made to Article 66 of the Bankruptcy Law, which states that after resolving initiation of bankruptcy proceedings, no claim may be filed or proceeded against the debtor except for, and then specific claims, specific types of claims, which do not appear to include the claims which were made in Kuwait. Quite what the effect of the insolvency is in Kuwait has not been the subject of any detailed evidence before me, and a degree of speculation has occurred. I had real doubts, in fact, as to whether Mr. Yates was entitled to appear to represent the defendant, since it seems his instructions come from the defendant's representatives rather from any trustee in bankruptcy. Nonetheless, his presence has been helpful because of the need for the terms of the Riyadh Convention to be debated and resolved. It is self-evident, however, that there are issues which arise in the context of insolvency where there appears to be an insolvency decree of some kind in Kuwait, but it has not yet been determined whether there will be a liquidation of the kind that is known in common law jurisdictions, or a reorganization of a kind which takes place in Middle Eastern countries, where the creditors agree to some form of arrangement, or the court imposes some scheme of arrangement. No application has been made to the courts of the DIFC to render the defendant insolvent in this jurisdiction. And it may very well be that claims could proceed in one jurisdiction, could proceed in this jurisdiction until and unless insolvency proceedings were begun here. But none of that matters for today's purposes in the context of seeking to transport a judgment of the Kuwaiti court for recognition here. The Riyadh Convention does not allow me to recognize that judgment at this stage, and if matters were to change, it would no doubt be in the context of the insolvency of the defendant and the absence of any further purpose being served in what are still currently extant Kuwaiti proceedings. The bottom line, therefore, is quite simply that, as matters stand, the claimant has no realistic prospects of success in seeking recognition of the Kuwaiti Court of Appeal judgment, and that it is not even right to refer to the Court of Appeal judgment as being executable, even if it is final and binding for its own purposes. This, of course, does not mean that it would not be open in circumstances which might obtain in the future to proceed with an action for recognition in this jurisdiction. But the complications are obvious, and the purpose might be very limited in circumstances where enforcement in the face of an insolvency proceeding elsewhere would present considerable difficulty to this court. So I offer no encouragement in that respect. As to what happens next here, I turn to the parties for their submissions in circumstances where permission to amend has been refused. So I don't know who wants to go first as to what the effect of refusing permission is.
Thank you, Ron. From the claimant's perspective, we'll obviously need to take instruction, but I imagine the issue of cost will need to be determined as a procedural next step, certainly.
Well, there's a question really as to whether in these circumstances I simply dismiss the whole action. Your original claim couldn't succeed, as you recognise on the face of it. This can't succeed as matters stand, and it appears to me the right course would be to simply dismiss the action. Questions of costs will obviously arise in that context, and then you can regroup if you wish to and bring fresh proceedings should you think that's an appropriate course to adopt, which I'm not encouraging you to do. But is there any reason why that's not an appropriate course, Mr. Mackenzie?
I don't believe so, Your Honour. I have no instructions on this point, but I don't see any reason why we would want to leave the proceedings open or open-ended, if I can put it that way, on the substance.
Yes, thank you. That's very helpful. Mr. Yates?
You're on mute, Sean.
I can't see you or hear you, Mr. Yates, for the moment.
How's that?
I can now hear you, but I can't see you. Oh, there you are.
Am I back? Good.
You're back with pictures behind you that I'm interested in, but you can mention
New College, Oxford, Temple Church, and a barrister that I have no connection with whatsoever, but it's just a legal print.
Are you in your own room?
Yes, I am.
Right. Okay.
Yeah. So, Your Honour, we say the appropriate steps now that the application to amend has been unsuccessful is under RDC 4.16 is to strike out the claim form, the first step, because that doesn't disclose any cause of action or any grounds for bringing the claim. And then under RDC 4.2(12) to dismiss, your powers are to dismiss or give judgment on a claim after decision on a preliminary issue. You say this is a preliminary issue and that you therefore have the power to give judgment, so we'd ask you to dismiss.
Well, I simply dismiss the claim because Mr. Mackenzie accepts that's the logical step to take. So the claim is dismissed. That means obviously you're entitled to costs, but I anticipate there may be a considerable debate as to what those costs might involve.
Your Honour, yes, I think the sensible step would be to see if the parties can agree it, and failing that, then there'd be listed for assessment. There have been, as you say, the parties have talked across one another for significant parts of this case. It has had some complexities. The extent to which any of those should be reflected in costs, or whether ultimately the costs should follow the event, could be determined in the event that the parties are unable to reach an agreement. I suspect our costs are probably less than the claimants, but still, whether they can agree them or not, we can only try.
Well, there are two possibilities, I think, in this context. Certainly the right order on the face of it is defendants have the costs of the proceedings to be the subject of assessment by the registrar if not agreed. Alternatively, if there's going to be some questions of principle, it may be that it's more sensible for me to deal with that than for the registrar. I don't think I'm in a position to give any real guidance today, save that I do take the view that there is certainly room for discount on the basis of some of the steps taken by the defendant, which were not in accordance with the court rules, and therefore not qualify for reimbursement. There is also the very question as to who was entitled to be here at any point. And whilst I found your submissions helpful, Mr. Yates, it's not a matter which the court can avoid.
Well, Your Honour, I found something that might be helpful. I unfortunately wasn't
Right.
able to give it to you, but to the extent it's relevant still for the purposes of the costs, if you
Yeah.
look in the bundle at page 911,
911.
911 is, and you can see from Article 144 of the Q8
Hold on,
law.
hold on, I'm not there yet. Yes.
So Article 144 generally
Yes.
talks about the effects of the bankruptcy having been ordered, and we understand that the liquidator hasn't been appointed yet, but the order has been made. But the effect of that is that Article 144 places limitations on the bankrupt's ability to conduct its own affairs. But the caveat to that is underneath that paragraph, which says that said prohibition does not prevent the debtor from taking the necessary measures to safeguard his rights in a manner that does not harm the interests of creditors. And we say that the existence of foreign litigation and the instruction of counsel to represent them in that foreign litigation is such an example of protecting the interests of the business in the meantime.
That looks to me a good point. Mr. Mackenzie can say what he wants to about that, but maybe that's not necessary at this stage because I'm not going to give any real guidance as to how an assessment should take place. Mr. Mackenzie, are you confident, or at least vaguely optimistic, that agreement may be reached on the question of costs?
I believe so, Your Honour. I think it's in some senses relatively clear cut, and in other cases, and I appreciate Your Honour's guidance with respect to the discounts, as you put it, following the defendant's actions outside the rules. So I think taking that into consideration and given Your Honour's indication as to where his mind lies, I think an agreement should be possible.
All right. Well, let me just then make an order that claimant to pay defendant's costs of the action, costs to be the subject of assessment by the registrar if not agreed, and encourage the parties to reach agreement. And if there's some awful problem of principle the registrar can't resolve, then no doubt it can always come back to me, and I shall have to dig out my notes and work out complexities that I don't wish to be involved in. All right. Thank you very much. As you're the claimant, can you draw up the order, please, Mr. Mackenzie, and submit it to Mr. Yates for agreement, and then to the court, and they will then send it to me for approval.
I'm grateful, thank you. Is it possible by way of some sort of slip rule that the reference to Article 144 might be taken into account in the comments made in the judgment once we have the written format, so that there isn't a public record of me potentially doing something I shouldn't be?
I'm so sorry. Yes. Yes. Well, let's. I will authorize a footnote to be added to the transcript of the judgment. I take it that you're going to want a transcript of the judgment.
Yes, Your Honour.
If nobody's interested in a transcript of the judgment, I will simply say that the comments in the ruling as to authorization for being here seem to me to be catered for by the terms of Article 144. And although that wasn't pointed out to me beforehand, it's relatively clear to me after the judgment that Mr. Yates was entitled to be here and to represent his clients in the way he did. If there's to be a transcript of the judgment, that should simply be added as a footnote.
I'm grateful, Your Honour, thank you.
The way it works, as you probably know, is that if you want a transcript, you apply for it, and the court will then produce a typescript which they'll send to me for approval and amendment of grammatical nonsenses, and a footnote will be added at the end. And it may be that when you write and ask for the transcript of the ruling, you should say to them, please also note the comments at the very end of the transcript, which you need to transcribe as well.
Grateful, thank you, Your Honour.
All right, well, thank you both very much indeed. Very helpful, grateful for your submissions. And no doubt see you in due course in other matters.
Great.
Thank you.
Thanks, John.
Would you like to
Okay.
sign out, and I'll have a quick word with the associate.
Thank you.
Sure. Thank you.
If Miss Dr. Sharina could sign out, please.
I'll remove it right now.
Right, has that, who's left in? Are we now,
Yeah, she's gone.
all right, okay, so would you mind turning your camera on? I always find it helpful to see the person I'm talking to.
I'm actually trying. Can you see
Well,
me
it
now?
doesn't.
I just got a pop-up notification says that we couldn't turn your camera on by Teams.
Okay, well, never mind. Say thank you very much for all your help. They will produce a draft form of order, and you've got the point that if they want to have a transcript of the ruling, no point in having a transcript of the whole of the proceedings, but just a transcript of the ruling and of the very bit at the end. Perhaps you, when that's done, you better send it to me for amendment of any obvious grammatical errors that I've made in giving an extemporary ruling. Are you happy with all that?
Yes, of course.
Thank you very much indeed. I shall look forward to seeing you next week, because I'm actually coming to Dubai for the first time for 3 years after COVID and all the rest of it. So it'd be nice to actually meet you.
I'm actually excited.
Well, I don't know about excitement, but could it be nice to see all the people I've been talking to over the last few years. Look forward to seeing you then anyway. Thank you very much.
Thank you.
All right, and have a nice evening.
You too. Bye-bye now.
Okay, bye then. Bye.